for this activity. So let's go there. Duties of a licensee. And there are two. You want to read? The holder of a license or a producer of a broadcasting station. You see now they introduce a new thing.
Station.
Broadcasting happens in
a station.
Are you getting it? Now we have introduced physical premises. A license is tied to a premises.
A station, a radio station,
yes.
A TV station.
Yes. Now the Act is introducing, it says a holder of a license or a producer of a broadcasting station, which means that when you look at the license itself, when they give it to you, they must mention an address. Are you getting me? Because the license must be hung for the public to see wherever the activity is
taking place.
Which means they must mention. There is no license which doesn't mention a venue. Now online, which venue do we give you? Let's continue. So
station or disseminating apparatus shall ensure that what is broadcast is not contrary to public morality. Retain a record of all that is broadcast for not less than 60 days.
That are the duties of a licensee. A producer. Now we have learned a new thing. Premises, a broadcasting station. They go further. Disqualification of a producer. Who can't be a producer. A person shall not be appointed producer
of a broadcasting station if that person is less than 18 years of age, is of unsound mind, is not ordinarily resident in Uganda, doesn't possess the requisite qualifications prescribed by the Media Council.
This also brings in some other technicalities. I don't know if you had a chance to discuss them before. Our Media Council was declared by court to be defunct. It is incapable of operation because what Parliament envisaged in 1994
is not what is
doesn't exist today in reality. That means the Media Council exists in name only, but it has no powers in reality. For instance, it is composed of 13 people, but of the 13, only 3 can exist. The 10 cannot legally exist.
Why?
The first 3 are the secretary of the Media Council will be a high-ranking, a person at the level of commissioner in the Ministry of
Information. ICT.
So any person, so that's a public official appointed by the PS. The PS gives the names to the minister. So that one exists. There will always be somebody at the rank of commissioner. Number 2, two eminent citizens appointed by the minister from the public. Those ones are easy to get.
Probably practitioners.
No, they don't have to be. They're citizens.
But senior.
Of integrity, that's it. Those are easy to get.
Can be retired justice.
They can even be farmers. Why are you so elitist? They can even be farmers, fishermen, preachers, anything.
3, okay.
Then now the rest come from what we call constituencies. The first constituency, which has 4, is called the NIJU. The National Institute.
National Institute
of Journalists of
Uganda.
Which doesn't exist. This was envisioned as a Ugandan Society of Journalists. But the qualification to be a member of NIJU is a degree. But the point, and then there must be a General Assembly to create a NIJU. So all the things have not happened in a long time.
Another constituency?
Another constituency is called... so NIJU is supposed to have 2 representatives from their own members. Then it's supposed to send...
so those are 5 now?
No. I was telling you of the 4. 2 of them are its own members, it send delegates.
Yes, the other 3 you talked
No, I was just breaking down NIJU's 4. Of NIJU's 4, 2 are delegates. 1 is a professor from the university. They must pick a professor and send to the minister to appoint. So the minister can't pick a professor from the university without NIJU. The minister needs to ask Niju first. But Niju is not there for the minister to ask. So if the minister...
So it is Niju that recommends to the minister.
Yes.
Then the minister confirms.
Yes.
But now Niju is not there. So it means this council is
Then I think also Niju sends somebody else. I think also
there's just a representative from the media practitioners.
Yes. So electronic media practitioners. That means they must meet and select the person, the name they're giving. The minister can't pick those names because they are representatives. They would have used another word. They would have said the minister can pick a media practitioner of his choice. No, it's not his choice. They are representatives. And they are licensed, so they are known. There is an existing rukalala of electronic media practitioners. They are licensees. So those licensees are supposed to have a statutory meeting for the purpose of electing a representative to give a minister to come and sit in council. Those are two. There is another category. They call them freelance journalists. Those who are not in Niju. For instance,
but they are journalists. Yes.
But they are journalists, for instance, from abroad.
Yes.
Accredited abroad and what? They're called journalists.
BBC, Al Jazeera.
Yes, they also have a representative. They must also send somebody in the council. What else? There's another constituency. But so those constituencies are missing. So
this is good enough.
That means that
the media council, which they are mentioning,
can't exist to set qualifications, and therefore it delays, it curtails, it curbs, it erases, it extinguishes, it holds in check the capacity of UCC to act.
You have used so many. You have used so many terms.
Let me use simpler ones.
Yes.
Without media council, without UCC, without an active
media council,
UCC must halt all its powers and dogs, and it must halt. It is frozen, in time.
Hey.
Yes, because who set the qualifications for media for a video producer?
UCC.
No, UCC can't. They say UCC must say media council gave us qualifications. You don't have them. But has media council ever set them
qualifications?
No. Since 1994, media council has been incapable of performing any of its statutory
functions.
So this is what we call inert. This is an inert provision.
Inert?
Yes. It's redundant.
Hey.
It's bogus.
That one is a big word.
It's fake.
Oh, that one is even much bigger.
We continue.
Yes.
So let us see other sources of meaning for broadcasting. We have come for these qualifications.
Yes.
So the rest are human activity. 18 years, sound mind, resident, and holder of qualifications which don't exist. So in Uganda, anybody can be a producer. Because there has not been regulation yet. Are you getting anybody? As long as they're 18. And even me, as an attorney, I can be. I don't need any qualifications because there are no known qualifications in law.
Media council has not set them.
It has no capacity. It doesn't exist. It's defunct. It's like UEB.
Hey.
It's in the grave. It died at birth. What exists is a grave for the media council. That office at Prime Minister's office is a grave. Limbo. It's in the limbo of
Council Isaac Ssemakadde.
It's in the limbo of legal mootness. My friend Mr. Paul Ekochu is a ghost walking.
He's a human being.
He's a ghost chairman. Ghost chair. You should add the word ghost chairman of Media Council. Mr. Paulo. Paulo. His official name is Paulo. Paulo Ekochu is the ghost chairman of the Ghost Media Council of Uganda. It died in 1995, 12th of September, to be specific. It died.
You have them even in the head.
We can get on internet.
It's okay.
But you've gotten it. I mean the death of a child. Why would you forget it?
So, okay. So now
it's a dead entity.
So now let's leave that.
So
now,
so we have given the meaning to the word broadcasting. Are you still in doubt that broadcasting is limited to TV and radio? Are you still in doubt?
According to the law here, which I am seeing, and you're not the writer, I think you have an argument.
Yes.
But now, there is what the law is saying, and then there is what is happening.
So what is happening is what we call a travesty.
A travesty.
Yes. A charade, a farce, an abrogation of law.
An abuse.
An abuse, a misuse, a gross abuse. A gross abuse. So it's not a mistake. It's not recklessness.
But also, Council Ssemakadde, what surprised me, these guys are very bold. They even went ahead and even mentioned the headlines these guys put up that called for their arrest. If you are saying, Council, that I am illegally operating without a license, but you quote only 2 stories.
Oh, yes.
You quote 2 stories. One is inside the story how top legislators shared a $5 million veto oil deal bribe, and then the other one is about the disagreement between a lawyer and a judge. When you look at Grapevine, they have a number of publications they have made. What is the basis of you picking these 2? That is, for me, that is what is actually the gist of the matter. Yes. Of all what someone has published, why are you using these 2? And that's number 2. But number 3, Council, these people are talking about corruption in the oil industry. Is it breaking news to hear that there is a corruption tendency in any MD of government? Why would this shock a judge or anybody of sound mind in Uganda today to hear that a journalist has reported about corruption in an MD of government? Then, when you hear about a disagreement between a lawyer, Ssemakadde, and a lawyer and a judge called Chan, so is it also breaking news? Haven't lawyers disagreed with the judges in broad daylight? So, these are the things that, for me, have actually shocked me. That they even get the audacity to quote these 2. Yeah? I don't know what your comment will be on that.
Well, first let me correct the date of death of Media Council. It wasn't 12th of September, as I said. It is 28th of July.
Yeah, I see, 1995.
1995.
Commenced on 28th July 1995 and died on the same date.
Yes. The Media Council died. Maybe other provisions, but I don't know. You see, there's another law you should take interest in called the Anti-pornography Act.
Anti-pornography Act.
You've heard of it? The Anti-pornography Act established a committee called the Anti-pornography Committee.
Yes.
The one which said it was going to buy a machine.
They had created a team with the comrade Martin Sempa was a member.
Sempa was a member, yes. There's a lawyer friend of ours, Charles Dalton Oponya. He was our representative of Uganda Law Society. Plus a very beautiful and engaging chairperson.
Knowledgeable.
I think she's a journalist. She's a journalist scholar.
Who is that?
She was the deputy vice chancellor at KIU. Now they made her chairman. I've forgotten her name. Barbara something. Let me get her name. Chairperson pornography. You don't remember her? But I'm not surprised because she kept quiet.
Yeah.
The reason is because
she's little hard.
Yeah, she used to make a lot of noise. The reason is because the Constitutional Court quashed Section 2. In Section 2 is called the Interpretation Act. They quashed the interpretation of pornography. It was nullified. It was found to be repugnant, unacceptable in a constitutional democracy. So there were two meanings. There was pornography in general and child pornography. So the definition of child pornography was retained, but the definition of pornography as general was removed. The number of reasons that the about 13 NGOs led by CEDOVIP, Center for Domestic Violence.
Oh, yes,
and something prevention. Yes. With others, Human Rights Network for Journalists and others.
They challenged it.
Yes, they challenged this law immediately. It was came in place around 2013. They challenged it. There was a decision around 2020 during the pandemic. It came out and they said the definition of pornography is unconstitutional. Now, when you strike out the definition of pornography, does the rest of the act survive? Because if you can imagine the pornography committee, that means it becomes just a committee. Because the definition has gone. So it becomes committee.
A committee on what now?
A committee on what? When you read all these functions, wherever the word pornography exists, the law has struck it off. So it doesn't exist. Now, here is the corruption that Ugandans don't understand. Why would the committee continue to receive wages?
When there is no actually...
When there is no purpose to which they can apply their human ingenuity to. Instead, they must put their tools down and go back to the drawing table and rewrite a new definition of pornography to present before Parliament to amend the law. Consistent with the judgment.
So right now they have no job.
Yes.
But they are earning. Is that the point you're making?
Yes.
There is no job because there is no pornography in context that you are working on.
Yes.
But then you are earning. Yes. So where are you earning?
Yes.
I get the point.
Yes.
So I wanted you to comment.
Kezab. Her name was Kezab.
Kezab.
Annette Kezab.
That looks to be on tour.
Yes.
Kezab is on tour.
Dr. Annette Kezab was the chairperson. So what is Kezab doing? First of all, I don't even think they should still be in office, because if they came into office around 2016, 15, their term of office must have expired by now. And then there was no wiggle room to appoint them again, because there's no activity for them to do. Unless they comply with the constitution, with the constitutional court's decision. You get it? Yeah, let us now return to the question you had asked. The scenario in court.
Yes, I wanted you to explain the context under which they could have used it to pick those two out of the many.
So what we have now is a culture of police misconduct, which is supposed to be checked at the stage of sanctions, sanctioning of a charge by the state attorneys, the department of DPP. But now we know that the department of DPP is a hooligan department. Yeah, it's overrun.
Don't use that word. Don't use wrong words. How can you say it? Hooligan.
This is where we are.
According to your context,
I am using proof.
Proof.
I will give you two scenarios that can help save you. But one, we use your current scenario.
Yeah, the one for journalists.
Yes, a police person draws a charge, because the charge sheet is drawn by police. They are the ones who draw the charge sheet and present it on top of a police file
and
request the DPP to sanction.
Not just to sanction, but to go through and advise.
That's what they call sanction.
Their job.
Yes.
The office of
yes.
Because the police officer may not even have studied this law. They are simply, but the job of the DPP, they don't understand it. The job of the DPP is to advise.
Yes.
Either change it and make it relevant to the current situation that the person is in charge, or even drop it.
So if you have a dutiful prosecutor in an office which has hierarchy, of merit, integrity, conscience, loyalty, or what we call fidelity to no other person but the law. Prosecutors at whatever rank don't answer to an individual except the law. They have what we call autonomy.
On their allegiance is on the law.
On the law.
Not on any other person.
Not on any other
Not
person.
even their appointing authority.
Not even their boss.
Hey.
Yes, a prosecutor can say I refuse. With respect. I refuse.
He refused.
I refuse, and it won't be insubordination. It can be insubordination on administrative matters, but not law, not legal interpretation.
So the insubordination
the legal interpretation, all of them in that department are lawyers, and they take the same oath to abide by the Constitution
and protect
it zealously to the best of their thought and faith. So
and
it is individual.
The best of their ability.
Yeah. So so you can't push me on the law, even if you are my boss.
My boss.
Yeah. The most you can do is you remove me and give the case to another who shares your opinion. But I cannot prosecute against conscience because I've been directed. It doesn't work like that.
So is this? Are you insinuating that this is what happened to our journalists?
What I'm showing you is that the first scenario is police misconduct, which you seem to not have any questions about. I think you have agreed.
Those were you have
come to understand that police misconduct is a cancer in final stage.
Final stages.
In final stages, there's nothing.
And that is the fourth stage.
Yeah, well, there's nothing you can do. So you have relegated the police
when
to the
cancer is at the fourth stage.
So as I understand, we have relegated the police to the dustbin of history.
I don't use the dustbin.
Because they are, how can they be active when they have a condition, a malignant condition of misconduct?
That's
do you know
is that an treatable condition?
Yes, you know gangrene?
Gangrene, no, I don't know.
Gangrene is caused by bacteria that eats skin and bone.
Hey,
yes.
Like cancer does.
Yes. Can you still put band-aid? If a person has gangrene, can you use bandage? As we call it, band-aid. In Uganda we call it bandage.
Because where do you tie it?
Where are you getting?
Yes,
so the police has gangrene.
The body and the bones have been eaten.
The Ugandan police
is suffering from
legal gangrene. It works. It's alive, it can breathe, but it cannot eat without ruseke, and it cannot pass out without ruseke. That's why it can't chase a thief. It can't. You see, for most Ugandans, they have never seen police at work. What they have seen are police hooligans beating them. The activity of beating is not policing. That's hooliganism. Are you getting? So for most of us, what we have seen are askaris. That's the colonial police force. The Uganda police force, which was formed in 1902. Yes.
It's 920 years old.
That one still exists. That is called the askari force. Askarism is still
and they were installed purposely to protect the
Captain Lugard.
Yes.
So Lugard's force still exists and has grown in stature.
Instead of consolidating all of them in one, we end up with that. What the intention could be and what we need to do, what needs to be done.
Scatter. Yes. Scatterbrain, scatterplot. It is called overcharging.
Overcharging.
It's an abuse of prosecution power called overcharging. Okay,
let's. Are you ready? Okay, I'm having here a conversation. Brother, a conversation with Comrade Isaac Ssemakadde, lawyer, brain trust head, legal head.
Legal brain trust.
Legal brain trust. The head, and we are actually discussing about the future of the media or the press freedom in Uganda. Just two of our comrades were arrested the other day, Tuesday, and they are right now as we speak. They are in Luzira, and here is another conundrum, as Comrade Isaac Ssemakadde now wants to say. Normally, these guys were charged on the same day, similar offenses, but scattered. They seem to be opening two files. What could be the problem? Because when I read the charges, they are actually the same, they are similar. The offender, the suspect is the same. The venue, you know, call it the outlet where they publish the story is the same, the director is the same, the reporter is the same. What could be behind the separation of the charges? Because now I am being told that even the days of their appearing in court are also different. You can appear on the 4th, they give you a bond, but they arrest you for another charge of the similar manner. What could be what is the meaning of that?
So, we have addressed police misconduct. You have gotten a sense of prosecutorial misconduct. We have a DPP's department that only in 1985, 29 years ago, is when it got independence from the police. But they were Siamese twins.
Siamese twins. Very identical.
Yes. and not just that, the police fought the professionalization of the prosecution department.
Yeah,
because they owned it.
Yes.
They were the original prosecutors.
It's their child.
It's their child. The original prosecution work. At the heyday of prosecution, that is during the Buganda riots of 1929, 1949, and again after the Kabaka had been exiled in 1955. During those time, it was called it was a time of great
instability and
yes. That's how they built Luzira.
Hey.
Yes, that's why Luzira is very near here. It was quickly built to
handle these rioters.
Yes.
But take care.
Yes. Otherwise, before the police used to use the colonial department used to use deportation.
Yeah.
They would arrest Baganda in Karamoja, Batoro in Buganda, Bagisu in Bunyoro.
They take you that far.
Yes, and they would arrest only ringleaders.
Yeah.
But now when riots came, and you don't know who the ringleaders are, so they had to introduce
construct detention centers,
a new
prison,
and nearby prisons. So they built local government systems and things like that. Yeah. And we move on. So now,
I want to turn.
So now, what you see this because a charge sheet. A charge sheet is supposed to have a second layer, a third layer actually, because even the policeman himself must be an officer of law. He or she must not do anything the law doesn't agree with. Yes. Article 23 of the Constitution. There shall be no restriction of an individual's liberty except in the terms authorized by law. And the first restriction is a police officer must be certain that they have observed breach of law. They must have some evidence that there has been breach of law. Now we have seen that the police officers are not really certain there was breach of law. So when they did the arrests,
the publication of the
yes, when they did the arrests, they must have looked at this evidence and looked at what scheme, under what law can we charge. And they charged them for lacking a TV and radio license. They charged the publisher of a website the offense of lacking a TV and radio license. So the police committed misconduct of the highest caliber. They were not checked by the DPP. Now the last check is called the magistrate at the time of taking plea. A magistrate must scrutinize the charge sheet. Scrutinize the individual. That's why they must define the individual thoroughly. And the magistrate must, at that point, operate as an attorney for the accused.
He must put himself in their shoes.
Because most people at that time are not what? Are not represented. That is why the magistrate must ask the question, have you understood any of the charges. Have you understood the charge? Have you thoroughly understood it? Can I explain it? And then they must ask you, what do you have to say? But here I keep hearing them say, how do you plead? No, what do you have
To say.
You may have so much to say, and they must give you all the time to say it.
Hey.
Even if you want to use a whole day.
Hey, sure.
It's your time. We are not supposed to prosecute people in plenty, such that there's no time for them to say anything when they're in the box. When they're in the box, the accused controls the show.
Hey.
That's the rule of law.
They must listen to you.
Yes.
But now most times it's the accused who are listening to the judges.
That's it. So we have now entered a new terrain of judicial misconduct.
Judges speak more than the accused.
So we have now
actually,
entered.
I am the one on the trial.
Yes.
I am pleading for my freedom. So I need to use all the possible words, gestures, explanations to convince
And
the
languages.
judge and languages that I am innocent. But instead,
Not just innocence. Your innocence is irrelevant. We presume it. At that time, what we want to know, because it's a public trial, is whether the police have been fair to you.
not whether I have committed the offense.
No, it's irrelevant. Evidence will answer that for us. What we want to know from you is whether the police have been fair to you.
Not whether I have committed the offense.
No. Whether the prosecutor has been
Fair to me.
whether the complainant has been fair to you. Whether the world has been fair to you. Whether the circumstances that bring you here
Are fair. Have been fair to me.
have been fair to you. We are interested in fairness.
I see some people coming in chains. Some people come when these things are broken.
And there's no alarm and there's no shock from the
Yes.
system of
the
Lugard.
the judge wants to listen to.
And Lugard says, I don't see. Like that magistrate of who is this young man, Ruchira? Ruchira Bashija.
Yeah,
What's his name? Kakwenzi. Yes. That magistrate, I have no words to define him.
Hey,
But that, he wasn't magisterial.
what did he say
He did hear.
when they brought him?
He did hear. He took Kakwenzi as a ghost. He numbed himself, his eyes and his ears, and said, you've had the charge, plead. Not guilty. Remand. So everything that had happened to Kakwenzi, he expressed no interest in. So he did not see himself as a check.
He was not seeing. He was not hearing.
He wasn't magisterial. He was just a man in a magistrate's chair.
What's the name of that magistrate?
He's now a judge
He's not a judge. What's it?
with a doctorate
Who is that one now?
in God knows what. Singiza. I forget other names.
Counsel, I wanted to address what I had reason so that
the scattering of charge sheets
Is it lawful?
is now.
First of all, is it lawful?
The short answer is no.
No.
It breaches section 86 subsection 1.
What is the intention of doing so?
So the intention is to harass the accused person. That's called judicial harassment. To harass the subject of colonial law. To harass the native. Using judicial proceduralism. Because we conduct administration of justice in Lugard's language and Lugard's culture, it mesmerizes and oppresses at the same time the native subjects, because this is not people's law. This is not even British law. It's not even English law. It's Lugard's law.
Captain Lugard.
Yes, it's colonial law. It's in legal jurisprudence we call it received law or imported law. Abazungu basunako. They picked pieces and bits of English law
They gave you.
and created for
Uganda.
empire. So it means that a different range, a very narrow range of rights was given to subjects of the colonial empire from citizens of England. Laws, legal institutions, and legal personalities operating in the colony operated on a different yardstick from those abroad. Are you getting me?
Yes.
So
Clearly.
here, what you see here, the magistrate, in this particular case, of course knows the law. I can assure you that. Because it's an essential activity of magisterial work. And it's routine and daily. Are you getting me? So there's a branch of law called framing charges. Rules as to framing of charges in the Magistrates Court Act. I don't know if we can. So the magistrates know it. They must pass interviews. You know? First and foremost, as lawyers, they must pass as lawyers. Then they must pass as magistrates. Then they get refresher courses. They observe other magistrates. They read decisions of higher courts on how they must. So they know this law. Okay? So why don't they apply it? Two reasons I can come to mind.
Why don't they?
Yeah, the first one is they have much contempt for lay people.
Joinder of counts.
They have much contempt. It's called contempt for people.
Contempt.
Yes. You see,
It's like somebody doesn't.
they take an oath. If you read the judicial oath, have you read the judicial oath? Let's read it.
Because I'm not one.
They take an oath. Oh, you should take an interest because these are your servants. They take an oath in the 4th chapter, in the 4th schedule of the Constitution.
Have you seen chapter 13?
Yeah, the 4th schedule. So this is 2nd schedule. So 4th schedule. 4th schedule, oath.
6th schedule. So you go down now. Go up.
Here we are. 4th schedule. 5th schedule. Now here are the oath. Oath of cabinet. Oath of secretary. So the judge is somewhere up here. Oath. Judicial oath. The 3rd oath.
I, Andrew Lumba, swear in the name of the Almighty God, solemnly affirm that I will well and truly exercise the judicial functions entrusted to me and will do right to all manner of people in accordance with the Constitution of the Republic of Uganda as by law established and in accordance with the laws and usage of the Republic of Uganda without fear or favor, affection or ill will. So help me God.
So, most important words, to do right
Yes.
to all manner of people.
All categories of people. All manner.
What happens is that the Lugard's disciples,
Captain Lugard.
yes, do right only by elites. They dress up properly. They respect media rights. Journalists, are you comfortable where you are? Then they follow the principles. But for ordinary people who are not elite, they do as they wish because they can get away with it.
Which is incorrect.
And because our watchdog capacities are also limited. You know the working condition of the journalist, who is the people's representative in court. Then there's what they call, so the second reason is called clickism.
Clickism.
The second reason is called
Clickism.
clickism, and you understand it's the biggest danger to justice.
Creating cliques.
All players in the justice sector study in the same school.
Yes.
And they are fed on the same ideologies. Petit bourgeois ideas.
Bourgeoisie.
Bourgeoisie. Not just bourgeoisie, but defenders of the bourgeoisie. Bourgeoisie are property owners, they are land barons. No. Lawyers are trained to be defenders of the bourgeoisie. Yes. So they feel big They are pumped.
Because they are defenders of the
bourgeoisie. They are pumped with importance. And they are given pompous jobs.
Pompous lifestyles.
Yes. They are allowed.
After all, they are next to the big men, the bourgeoisies.
And on top of that, dung heap.
Dung heap now, that's
sit judges.
Dung heap.
So yeah, it's this dung heap of colonial watchdogs. Judges are at the peak.
Yeah.
They are the most atrocious defenders of the bourgeoisie.
Yeah.
And the biggest weapon they wield in defending the bourgeoisie is called the fly whisk. You know fly whisk?
Yeah.
Fly whisk. Rungu, the one Figi had, the late Moi, Daniel Arap Moi.
This stick.
That's called the rungu.
I have it.
Yes, that's the rungu. Yes.
I have it.
You know it's purpose. It's purpose. The Muslim calls it because the Muslim can understand it, so he calls it fly whisk. That's for beating flies. But in Japan, they have those ones like for.
It's actually the son of Amini who gave it to me. He gave it to me as a present.
Yes. So judges have rungu.
Hey.
They call it decorum and etiquette.
Yes.
They insist on decorum and etiquette. But that's nonsense. For allow me make my mistakes. Be patient with my mistakes and abuse.
But they have little time to really listen to your mistakes and
I beg your pardon?
They have little time. They have a lot of things to do. They have a lot of clients to attend to. The inmates, the suspects are.
All that is etiquette and decorum.
Yeah, but now if they are going to allow you, Comrade Ssemakadde, to abuse everyone for the next 3 hours, then they will only attend to you. Yet they have hundreds of people dying in the jungles, in the jails.
Well, you are bought into their nonsense.
I'm just imagining.
I get you.
I'm
So judicial misconduct is a whole chapter which we shall need to discuss in a series of discussions. But what you have just pinched is just one example. Because the magistrate is the final check. Okay? On in the interest of the public. Is the final check on abuse of law. Okay?
And the protection of the public.
Yes. That's the oath they took.
Right.
To perform, first and foremost, to perform a judicial function. You know what that means? Judicial means neither executive nor legislative. I'm the one to listen to you complain about the unfairness of the law. It's legitimate. You have the right to call the law stupid in my face. Yes. Because I didn't make it. It shouldn't pain me. You are the citizen. You are the absolute sovereign. I'm the only one to remind you that you have the power. That's the meaning of judicial function. To check the executive and to check the
legislature.
So that's it. But do you see that our magistrates,
the judicial system,
are so tied to defending the law as is and defending the powers that be of the day?
The justice.
Yes. They think they are servants of those two institutions. They have never reached the judicial shore. They pretend they have the garb, the uniform and the chair. But they're not performing a judicial function. They are performing an executive function.
Okay. Now, Council Ssemakadde.
In this particular case, there's a rule. The first rule is called, are the charges clear? Have you been charged properly? Now, one of the forms...
So you're calling joinder?
One of the forms of... one of the rules of charging is called joinder.
Joinder of accounts.
Joinder of accounts. So there are two forms of joinder. To joinder is to join together.
Yes. Bring together.
Yes.
Match.
Yes. So in the interest of justice, the police, the prosecutors and magistrates are supposed to ensure that there is a proper joinder whenever occasion, whenever it's possible to do so.
All cases are brought into one charge sheet.
Let's say, for example, Mosisi is accused of committing a robbery.
In Nansan.
In Nansan.
The same Mosisi is accused of committing
now when they catch him with a bag, and it has phones, it has TV, you know, maybe.
Yes, phones, TV, and maybe a computer.
Yes.
But
each of those is an offense.
Yes.
Is it fair to
charge him 3 times?
To charge him 3 times?
No. It is theft. So it is one offense. But then we're going to list what he had stolen.
Yes. Now, it's an abuse. So to create maximum abuse of law, a very malicious officer working together with a malicious prosecutor,
DPP,
with a magistrate who will look away from this malice, clickism, who will join the clique of malice against Mosisi, will allow Mosisi to be charged with 3 separate offenses, and they give those cases separate days, such that if Mosisi wants to apply for bail, he will have to apply 3 times.
Yes.
And one of the reasons they will deny him bail is that he has pending cases.
Yes.
So Mosisi gets judicially harassed through proceduralism. He's beaten. It's a form of violence. But this time,
organized violence.
Yes. Systematic violence, bureaucratic violence.
So in other words, to put it in context, these journalists of ours have been charged twice, and yet the content are the same.
Yes.
So it is the judicial abuse.
It is perfect clickism. It is police abuse, prosecutorial abuse, sanctioned and sealed finally by the person who took the plea. The magistrate had to join the clique. It was possible for the magistrate to say, wait a minute.
These are the same things.
And you the one who appeared here yesterday? On this prosecutor, why are you splitting?
Yes.
Please join. If you want to join, I am Joe. I am joining them. I am issuing an order that this file will move together with the other one from now on. Prosecutor, when we come back tomorrow, the next day you bring a common charge sheet.
I have seen this. You know, right now I'm complaining about this, but there is somebody in Imbarara court. There is a man they have jailed now for over 3 months, I think.
By splitting.
It's called Titus Tugume. I know him. Titus. The issue is about these people he was taking out. He has a company, I think, that does external recruitment. What the judges in Imbarara did, they made every complainer made a separate case. So if you have 20 people complaining about you taking their money and later on not getting them the jobs abroad, they have opened all those cases and files, each one separate. So
this is ongoing.
It's ongoing.
So I can imagine he's in jail.
He's in jail.
I can't get out.
And he has even failed to. Where do we begin from?
So
and what they have done also, the courts are different.
Yeah.
These files are here at Imbarara High Court. Another ones are in Ismail Chabenda. Another one is, you know, even joining them, bring them together.
So let me now. You, Mr. Titus, does he have a lawyer?
He has, but you know those.
Does he have a lawyer? It's a simple question.
He has a lawyer, but not very good.
So I can assure him, even if he had a very good lawyer, the lawyer may not perceive error because of clickism. That the lawyer consumed the same fake petty bourgeois ideologies as everybody else in the legal chain.
The lawyer has actually been fighting to consolidate them. He called them consolidation of these charges. The lawyer has been fighting to consolidate them into one.
Oh, if
but this has taken him now 3 weeks, and he has.
Oh, yes, okay. So 3 weeks.
He doesn't seem to be successful.
Well, 3 weeks is probably.
But also the money involved. The money involved.
No, that lawyer is not guilty of criticism.
No,
he's
not
challenging the system.
He's challenging.
He's challenging the system. He's rejecting criticism.
Yes, he's rejecting. He had a discussion with him.
So what he's probably
and he told me that's what he was doing.
What then, again, maybe his limitation. Again, it comes again to part of criticism called etiquette. That he's failing to conceptualize Titus's situation as a national scandal. And he's treating it as a private concern of Titus alone. Yet it is contempt for all Ugandans by people whom they pay salaries. Are you getting?
Yes.
So the lawyer is probably afraid of escalating the matter to that level, because they are taught in the clique hill that calling a press conference to expose injustice inside our clique is bad manners.
He's indisciplined.
Is indiscipline. So are you getting?
I'm getting.
Yeah. There is a case.
Yes.
The leading case in this situation is called Kazinda.
Yes.
As you know,
Kazinda
was accused of how many instructions? What are they called? Instructions to Bank of Uganda. Are you getting? He was a principal accounting officer, so he would sign instructions for the ministry, for OPM, to Bank of Uganda. So he's accused of quite a mountains of instructions. Now the government separated these instructions to the bank. Each instruction they were making a case. So they try one batch, 180 instructions. When Kazinda beats them, they bring another batch. Do you know what happened?
Yes.
Kazinda spent 7 years fighting the first batch. He was convicted and sentenced to 5 years.
Then
when he appealed, he won that case.
Now they brought another batch.
But you see, he had already spent 5 years.
Yeah.
So the court couldn't give him back his time. And then they brought another batch of instructions.
Same ingredients,
same time. They brought another batch. Because this is after 10 years, they bring another batch of 10 years ago, which they could have brought at the beginning.
Yes.
And he knows that there's another batch they're talking about from the evidence. So he filed a constitutional petition to the Constitutional Court saying, I am being judicially harassed by those who have the power to prosecute. They are choosing to harass me through their power to choose a time and an offense to bring, arising from my job at OPM. Yet they could have brought all those charges
together
at once when they said I was the baddest man in the OPM. You bring all the charges because I no longer have a job now. So accuse me all the offenses related to OPM today.
I handle them for once and for all.
Kazinda lost money. He hired about 7 lawyers, all the biggest lawyers in town he hired, and they all quit. But imagine, all these lawyers are taking money. No point mentioning names, but it's public record. Now he represents himself because he's out of money. So the Constitutional Court settled the matter and said it is now illegal, unconstitutional for police and prosecutors and magistrates or judges to fail to notice an injustice done to the person charged. You must reduce harm, you must reduce expense, you must reduce delay, and you must reduce abuse of the judicial system.
Processes.
Yes, simply because you have the power to prosecute, doesn't mean that you prosecute recklessly.
Yes. We may not finish.
So this is what happened here.
This is what is happening to our.
It's a breach of Section 86(1) of the Magistrates Court Act, the rules of joinder. It's also a breach of the law as interpreted by the Kazinda case.
Yeah.
Yes.
It has already been settled. Now these guys are doing it's like they are repeating mistakes that have been already been settled.
These are hooligans. They don't listen because the Constitutional Court has spoken. Who, if a person disobeys Constitutional Court, what do we call them?
Not abuse them.
Let me ask you, if a person disobeys Constitutional Court, what would you call them? A person says, I will not obey the Constitutional Court of Uganda. I step on the Constitution.
Let us look for another term.
If a person says, I step on the Constitution, what do we call that?
Okay, if we are not to use that term, which one would you use?
There's no other term. You see, the Constitution settles the 4 boxes of civil conduct for all, both the governors and the governed, under the principles of rule of law. When you step outside the constitutional bounds, you have rejected constitutional order. You have rejected the republic.
So what term do you want to give those ones?
You may even call them traitors, because then you have declared treason against Uganda.
Okay, maybe that one is a bit civil.
You are a victim of criticism.
Ladies and gentlemen, Comrade Isaac Ssemakadde here. He's a brain, ladies and gentlemen. He's a brain. But I kindly ask you to watch our show on the Spy Television, and of course follow us on our social media platforms. We are there. The TikTok accounts are there. The Spy Uganda, Spy Television. My name is Andrew Irumba Katusabe. Let's meet again when we meet. God bless you. Counsel, thank you.
Pleasure. My name is Isaac Ssemakadde. I'm the founder and the executive director of Legal Brains Trust.
Legal Brains Trust. I know that you visited you several times at the Bombo Road.
Yes, I'm also of counsel to your organization, the online.
The Ideologies. Yes, you are counsel. Actually, when they next come for mention of their cases, I think they applied for bail. We will make sure we are there.
So you can now switch off and we discuss their case.
Yes.
So I don't know why